Welcome to the Judicial Committee of the Privy Council, where today we are hearing the second day of an appeal from Trinidad and Tobago. The appeal is concerned with a dispute arising out of the construction of a national stadium for Grenada, and the case is called National Stadium Grenada Corporation and NH International Caribbean Limited. We're at a stage in the hearing when we are hearing counsel for the respondent, Simon Hughes, Queen's Counsel. I'll call on him very shortly. I should first mention that I'm hearing the case with four judicial colleagues: Lord Lloyd-Jones, Lord Briggs, Lady Arden, and Lord Sales. Mr. Hughes, if you're ready.
Thank you, my lord, my lords, my lady. I wanted to, I've cut short, or I'm going to seek to cut short what I was proposing to say. And with that in mind, I wanted to begin by saying a few words about applicable legal principles. I don't propose to spend very long on this. There are, in my submission, only a few points that really concern this appeal. First of all, you were taken yesterday to the article in the Law Quarterly Review by Mr. Millett QC, as he then was. I don't propose to take you back to that. However, as the second paragraph on the first page of that article makes plain, on questions of whether a trust has come into existence, in this case, it is said in favour of NH or other contractors and suppliers, the question is always one of intention, the intention of the parties. What Mr. Millett QC said, as he then was, is it all depends on the intentions of the parties. And we say that that is critical, and indeed the central legal principle of relevance on this appeal. Next point, and very quickly, the appellant yesterday seemed to criticise the Court of Appeal's approach, and particularly there seemed to be criticisms directed at the Court of Appeal's reliance on twin sectra. You were taken yesterday in the bundle to part of the Court of Appeal's judgment. And if I could ask you to go back to page 34 in the bundle, please. And in fact, if we go to the preceding page, you can see this is part of paragraph 61 of the Court of Appeal's judgment. And then over the page at page 34, the final sentence of paragraph 61, Mr. Hughes, relying on twin sectra, submitted that there was the absence of the specific arrangement with specific language to show that NH was an intended beneficiary of the trust. Just to be clear about that, that was not, that is not, the Court of Appeal becoming confused on the subject of quist-closed trusts, for example. And I can perhaps just show you what my client's skeleton argument said on its appeal in Trinidad by taking you to page 838 in the bundle. You should have on page 838 at the top, Roman 2, this is part of my skeleton argument in the Court of Appeal. The judgment is very confused, I say, but then at A, the question of intention to create a trust which imports an objective test is always central. In language used in his speech in the House of Lords in twin sectra, and then I give the reference, redolent of the conclusion reached in his articles Queen's Counsel Law Quarterly Review some 17 years earlier, Lord Millett said, "This depends on the intention of the parties collected from the terms of the arrangement and the circumstances of the case." So when one, in my submission, reads that part of my submission to the Court of Appeal, one then understands the reference in paragraph 61 of the Court of Appeal's judgment. And there is, in my submission, no confused or wrong thinking in paragraph 61, but rather the Court of Appeal acceded to the submission that the principle of law which they had to apply was whether, applying an objective test to the project agreements and the other evidence before them, there was sufficient intention manifest to create either a trust in favour of NH or others. And so we say that the legal principle is a relatively straightforward one, and it was correctly applied by the Court of Appeal. Now, the appellant goes on to say that the Court of Appeal took various wrong turns in not looking at the question of intention. I don't propose to spend time going through paragraphs in the judgment of the Court of Appeal, but I would invite the board, please, to look at paragraphs 52, 53, 57, and then, importantly, 64 and 68 of the Court of Appeal's judgment, where in my submission it is plain that the Court of Appeal were directing themselves to the correct question, namely the question of whether an intention was manifest to create a trust, that exercise being one of looking at matters objectively, as I've already mentioned. The next point I wanted to touch on is that the appellant suggests that the Court of Appeal in Trinidad was responsible for the misguided excursion into Quist-Close Trust. That's, on analysis, not right at all. And I have 3 points on that, if I may. The first point, the idea, or the submission, that the decision in Barclays Bank and Quist-Close provided NH with a route to a trust in its favour originated with NH. It's been central throughout their case. It was a part of their submissions to Justice Raj Kumar. It was central to their defence of the judgment on appeal before the Court of Appeal. And perhaps if I make good that submission very briefly with one reference, we will need to go to page 857, please, in the bundle. Page 857 is part of the appellant's skeleton argument before the Court of Appeal. And what the board will see just below paragraph 16 is a reference to the Quist-Close argument. I don't propose to go through it in any detail, but what the board will see is that from paragraphs 17 through quite a lengthy treatment to paragraph 34, ending on page 866, the Quist-Close argument, so-called, is developed. And it's developed in substantially the same terms, in fairness to my own friend, Mr. Fitzpatrick, who appeared both before the judge and in the Court of Appeal. It's developed in substantially the same terms before the Court of Appeal as it was before the High Court judge. So the notion that Quist-Close Trust reasoning, if I may put it that way, was somehow an excursion or a flight of fancy that was taken first by the Court of Appeal is not correct. The Quist-Close analysis was rejected by the Court of Appeal. My second point is that my clients NS have always contended that quist close type analysis simply doesn't work on the facts. And shortly, my clients agree with footnote 29 in the appellant's case. That's to be found in the bundle at page 1151, where in a relatively lengthy footnote, my learned friend begins, footnote 29, a quist close trust properly so called would not assist NH. As such trust or resulting trusts and therefore apply in favour of the person who provided the relevant monies. Well, that's what we've said all along. We rather agree with that. And that brings me to my third point, as it were. That footnote is just one way in which one can, in my submission, examine the judgment of Justice Raj Kumar and establish that it is wrong and his approach was wrong. He accepted, hook, line and sinker really, the submissions of NH around quist close trusts and was wrong to do so for reasons inter alia provided in the appellant's case at footnote 29 on page 1151 of the bundle. Just as a development of that point, we say, with the greatest of respect, of course, that Justice Raj Kumar's reasoning is unsupportable, and indeed from yesterday, not apparently, in fact, very much supported by the appellant. My learned friend took some time yesterday to go through parts of the judgment of Justice Raj Kumar, and we say that exercise was itself sufficient to identify some rather fundamental problems with the reasoning and the conclusions and orders which rest upon the reasoning of the learned judge. If I just draw the threads together in relation to the law, we say that really NH and with respect the learned judge have made two fundamental errors, NH throughout and the judge in his judgment. But the first error is this: the idea that since the stadium could not be completed without work from NH, and that the intent of the facility was to finance that build, the idea that those factors alone were sufficient to create a quist close or indeed an express trust in favour of NH or other suppliers, we say that that is threadbare as a matter of an analysis. The predicates, the assertions which are gathered together to support the notion of a trust are simply insufficient. And frankly, if the matters I've just referred to were sufficient to give rise to an express trust, commercial life would be very different from the way it currently is. Second error, we say that communication is not itself sufficient. That there was a point yesterday in the course of argument where my learned friend mentioned that arrangements communicated to NH might be sufficient to give rise to a trust in its favour. We say that communication in those circumstances would never be sufficient. It would always be necessary to first determine the effect in law of the arrangements. There might then become a question of communication, but one can't, in my submission, pull oneself up by one's proverbial bootstraps by simply relying on communication alone. So we say there are those two fundamental threads of error within NH's case. I wasn't proposing to say very much more, in fact, any more on the law. And I wanted now, if I may, to turn to the project agreements and deal with those relatively briefly. But before I do that, members of the board, I wanted to make 4 general points on the project agreements. First, this is a relatively complex network of agreements, not at all unusual in the financing and construction of major projects, either in Trinidad and Tobago or elsewhere. Second, we have seen and will see relatively sophisticated and careful drafting, particularly around the facility and the way in which it is secured and operated. Third, NH's only contractual relationship was its relationship with ICS. That is common ground. Fourth and final point, NH is a well-known and highly experienced contractor in Trinidad and Tobago, and one is not here, therefore, dealing with parties who have wandered into a network of agreements or arrangements, as it were, for the first time, or on the basis that they are ingenue to this type of work. It's on the basis of those 4 points that I'd like now, if I may, to look very briefly at the facility agreement. I wanted to look at the facility agreement in execution copy, if we may. That will mean going to page 401. I hope you have that. 401 is the signed, executed version of the facility agreement. And I'd ask the board, first of all, to note just below, well, obviously the parties to the agreement are clear on its face, whereas the trustee has agreed to arrange a bond issue on behalf of the company, that's NS, the proceeds of which to be used to construct a sporting complex at Queen's Park, St George's, in the island of Grenada, upon and subject to the terms and conditions of this agreement. So we say that that language is already very clear about the role and status of NS and the basis and intent of the facility. There are a number of definitions which begin at 402 in the bundle. But they are rather important. My learned friend pointed you to 1.1.3, the definition of the builder. That is NH. There are 2 references to NH in this facility agreement. One here in the definitions, and secondly, as my learned friend took you to yesterday, one of the conditions subsequent to the drawdown was that NH was to provide a performance bond in respect of its subcontract works. But those are the only 2 references to NH. The other definitions are worth noting. 1.1.9, event of default. I will come on to that because certain things happen upon an event of default which very much touch and concern NS. Over the page at 403, if I could pick up 1.1.20, there's a definition there of mortgage. It means the proposed collateral mortgage and collateral charges between the company and the trustee pursuant to 5.5. Over the page, if I may, 1.1.29, trust deed means the deed substantially in the form set out in Annex 2, with only such variations thereof as the trustee may approve. I propose to come back to the trust deed in a little while to look at some of its provisions. if we then look at the operative terms, the facility 2.1 at the bottom of page 404, upon and subject to the terms and conditions of this agreement, and in reliance on the representations and warranties in clause 8, the trustee, CLECO, agrees to make advances to or on behalf of the company up to an aggregate maximum principal amount as follows, and then one sees that. And then 3.1, the facility shall be used solely for the purpose of the project. And of course, 3.1 is where, before the judge and in the Court of Appeal, NH said, well, since the facility is for the sole purpose of the project, and since also NH is going to be building quite a large part of the project, it follows, so the argument went, that the facility, capital F, the funds, were somehow impressed with a trust to which NH or other suppliers were beneficially entitled. And it's a point I've made already this morning. We say that is nowhere near sufficient for the purposes of creation of a beneficial entitlement in NH or indeed in anybody else. Condition precedents are dealt with at 406 in the bundle. My learned friend took you yesterday to 4.2c, which is the only reference, apart from in the definitions, to NH as builder. You've been taken already to clause 5, 409, interim bonds, floating rate bonds, and security. If I could ask you to please look at 410, clause 5.5. The company agrees to execute contemporaneously with this agreement, 1, a collateral deed of mortgage in favour of the trustee over the lands, 2, a collateral charge over the performance bond to be established in accordance with 4.1.4. We then payments 7.1. All sums payable by the company under the trustee to be paid in full without any set-off or counterclaim whatsoever or any deductions on account of any taxes. And then representations and warranty in clause 8, bottom of 410. The company represents and warrants as follows. And then, if I may just go briefly, please, to termination in case of default, which is clause 9, 412. And then within those provisions, we could go, please, in the interest of time, straight to clause 9.2, page 415. If an event of default occurs and is not remedied within 30 days of such occurrence, then in any such event and at any time thereafter, if such event is continuing, the trustee shall by notice in writing to the company, NS, cancel any unadvanced amount of the facility, and the entire amount of the facility then outstanding shall become immediately due and payable from NS. Members of the board, I mentioned that I would come back to the trustee, and I now wish to do that very briefly. My learned friend indicated yesterday, quite rightly, that the trustee is not annexed to the document we've just...
Just before you do that, though, Mr. Hughes, could I just pause for a moment on this agreement that we're looking at? It's quite clear that the disbursements have to be paid out of the facility, isn't it?
Yes.
So that there is, in that sense, the identification of a specific fund for the payment of the disbursements.
That's correct, my lady.
So, and I think you would agree that this document has to be construed with contemporaneous agreements.
Forgive me, I missed that.
It has to be construed as one of a suite of documents.
Yes, I'd accept that, that there has to be an exercise of construction which has regard to all other things that were happening at or about the same time within the knowledge and contemplation of the parties. And that would include other documents executed at or about the same time.
And for the purposes of an equitable assignment, because I think you've completed your submissions on the law, you've dealt with intention to create a trust. But is intention to assign or to make an equitable assignment rather different?
No, we would say no.
So, but you're then contemplating an assignment by way of trust. Is that right?
Well, my submissions don't contemplate any sort of assignment. What appears to be said is that if and to the extent that my learned friends' clients lose on a trust directly in their favour, then there was a trust in favour of another party, principally ICS. So they have to get through that hoop, as it were. And then they say there was an assignment of ICS's interest, including its interest as beneficiary under the trust I've just mentioned, which was assigned to NH.
But what the judge was talking about was an alternative proposition, namely that the effect of the agreement we are looking at is that there was an assignment to the persons to whom the disbursements would be made.
My lady, I hadn't quite read the learned judge's judgment as concluding that there was, as it were, within the facility agreement itself, an immediate assignment to third parties. The way we certainly had read the judgment is that effectively the trust question, the trust point, has to be resolved by reference to collection of documents and conduct and so forth. But if that is then, if my learned friends' clients fail on that, then there is a separate question of assignment, not arising out of the instrument that we're looking at now necessarily, or at all, but arising out of correspondence to which my learned friend took the board yesterday.
But he is accepting that a direction to pay out of a fund is the ingredient of an equitable assignment.
The judge?
Yes, that's the authorities that he cites.
Yes, my lady, I'm hesitant only because what the judge has analysed and concluded is not, in my submission, altogether easy to decide.
Well, he was citing Lord Wensleydale and Lord Truro. I suppose if I could just say that he cited those authorities, which show that a direction to pay out of a fund is enough to create an equitable assignment. And therefore, my question to you is, could it not be said that the in clauses of this agreement, and perhaps we could better look at it after we've seen the development agreement, constitute an assignment at the first stage from NS to ICS?
We say no, my lady. We say no. And with the greatest of respect to the learned judge and the judgment, that there are aspects of the judgment where a little bit like the scriptures, that there's an awful lot in there, and almost lots of propositions could be supported by reference to the text.
Yes, I always thought of that as the Virgiliana Sortes, but it is the proposition of law that an equitable assignment actually doesn't require the intention to create a beneficial interest.
Yes, well, my lady, we simply don't accept that there is sufficient within this facility agreement to constitute an equitable assignment of the sort that would assist my learned friends.
Right, but we do agree that the disbursements would be paid out of the facility.
Yes, we do.
Good, thanks. Let's come back to it.
Many thanks. Could I go back to the trust deed now? My learned friend's quite right that the best, in fact, only place to find the trust deed is at page 290, appended to the legislation. Page 290 of the bundle, if the board have that. Annex 2, could I draw attention to the following features? The board will note recitals C and D. Net proceeds from the issue of the bonds are to use to finance the construction, etc. And D, the trustee has agreed to act as trustee of this trust deed for the benefit of the bondholders, on and subject to the terms and conditions set out in this trust deed. If I could then invite the board to look, please, at page 295, it's clause 2.02, covenant to repay and to pay interest. 3 lines down, the project company shall pay to or to the order of the trustee in dollars, in immediately available funds, the principal amount of the bonds, etc. And then if I could ask the board to look, please, at 298, clause 2.05, all payments of principal by the project company in respect of the bonds will be made in dollars, without withholding of, etc. Could we then please go to the next page, 299. 4.01 references the principal amount, that's the 23 million US dollars. And then 4.02, the proceeds of all original bonds shall be receivable by the project company and shall be applied for the purposes set out in recital C of this trust deed. And I've taken you to that. And then could we go, please, to 302 in the bundle, clause 8.01, enforcement by the trustee at any time after the bonds shall have become immediately due and repayable. The trustee, to the exclusion of the bondholders, may, at its discretion, and shall, on the request in writing of bondholders holding not less than at least 1/4 of the principal amount of the bonds outstanding, or, if so requested by extraordinary resolution, claims and demands to which the trustee may be liable, and all costs, charges, and expenses which may be incurred by the trustee in connection therewith, and without notice take such proceedings against the project company as it may deem fit. And then clause 8.02, trustee entitled to prove in any winding up of the project company in respect of the principal and or interest payable in relation to the bonds or other monies payable under any provision of this trust deed. And then towards the bottom of that page, if I may, 9.01, if the project company is wound up, whether compulsorily, voluntarily, or subject to the supervision of the court, all amounts payable to and received by the trustee and payable by and received from the liquidator of the project company, NS, in respect of the bonds, by way of principal and or interest and, or otherwise payable under the provisions of this trust deed, will be received by it on trust for application, and then first and second mentioned in 90101 and clause 90102. And then finally, if I may, a little lower down, 9.01.03, without prejudice to the provisions of this clause 9, if the trustee shall hold any monies which represent principal, premium, or interest in respect of the relevant series of bonds which have become void under condition 11, the trustee shall, subject to payment or provision for the payment or satisfaction of the said costs, charges, expenses, and liabilities, and the remuneration of the trustee, pay the same to the project company. We say, my lords, my lady, that the provisions of this trust deed, very detailed, carefully drawn, point entirely against NH's trust point on this appeal. if there had been any intent to create a beneficial interest in NH, then that would surely have been spelled out in the facility agreement, or at any rate in the trust deed appended. We also say that this document supports NS's case on the entitlement issue, which is that the facility, once drawn down, is vested in NS, and NS becomes wholly responsible for it vis-a-vis CLICO. And then finally, the only beneficial interest created by the facility agreement is a beneficial interest on the part of investors and bondholders vis-a-vis the trustee. I was going to leave the facility agreement at that point and briefly touch on the development agreement. That's to be found at page 417 in the appeal bundle. I don't propose to spend very long on this document, save to pick up a few of the points that are referenced in the respondent's case. The parties to the development agreement are apparent on its face and at all events well known now to the board. Minister of Finance of Grenada, ICS as developer, CIB as the so-called financing agent, and NS as the project company. Just one point in relation to the definitions at 418. There is a definition of contract documents at 1.1.10, the proposal, the award, the memorandum of agreement, and this agreement. There is then a definition of the contractor, which is the developer in capacity of contractor. No references to NH's subcontract with ICS. No references here to NH. If I could then ask you to turn to clause 6, a provision that my other friend took you to yesterday, and in particular 6.5, under and pursuant to the facility agreement, pay or cause to be paid through the project company all monies due under or pursuant to the contract documents, which is a defined term, to the developer, consultants, suppliers, and other providers of goods and services in relation to the project. We say that this provision neither creates an express trust in favour of NH or indeed any other supplier or contractor on the project, and secondly, does not constitute any form of assignment. Frankly, the language here is, we say, purely contractual. It is largely administrative in its nature and intent. First, it is quite insufficient to constitute a declaration of trust in favour of ICS or in favour of NH. And next, we say it does not constitute an equitable assignment or any other form of assignment to either NH or anybody else. But as regards the proposition that it might create an assignment to NH, we say that the language is far too vague and amorphous to be used for that purpose.
Coming to the opening words, under and pursuant to the facility agreement, that's a reference back, isn't it, to the fact that the facility agreement imposes an obligation to make payments out of the advances, a direction out of a specific fund.
Milady, and it's an obligation expressed in those terms. It is a promise, a covenant on the part of CLICO to pay out in accordance with the terms of the facility agreement, the facility, to NS.
No, sorry, to make payment of the disbursements, which is not necessary to NS.
In relation to the disbursements to NS's order.
Yes, so that would include the subcontractors, because we know there's a mechanism for bringing in the verification of the subcontractors' invoices and so on. You have to read this clause, do you not, with the one that we previously saw in the facility agreement, because that's what it tells us to do under and pursuant to the facility agreement.
So, certainly I'd accept, my lady, that one has to read these two agreements together, but because they effectively dial up.
Yeah. Yes, they are in sync. And it then goes on to pay or cause through the project company all the monies, but the project company is the company which will supervise the rendering of the verification, will it not, through its contractors and subcontractors?
Yes.
So going back to Lord Wrenbury and Lord Truro, could this be argued to be, it could be seen as an equitable assignment, the two together, in favour?
I wonder if I can intervene. It might be helpful if we had in front of us the passage which Lady Arden's referring to. We find it on page 147 of the bundle. I think this is the passage she has in mind. From Palmer and Carey.
Yes.
Yeah. Well, perhaps we can take a moment to read that and then consider how it might apply or not apply. I'm presuming that what Lady Arden has in mind is the second alternative referred to in that passage.
Yes, a direction.
So this would be an order given by a debtor. The debtor presumably is NS.
Yes.
To his creditor CIB.
No, pay such funds to the creditors. The creditors are the suppliers, and ICS. They obviously can only operate as a contract. If it is an assignment at all, it will be take effect in contract until. So
what's envisaged as being the order given by NS to?
Well, it's concurrence in the earlier agreement to the arrangements and mechanisms for the payment of creditors, of the suppliers and the ICS. ICS, of course, the principal contractor.
And Milady is focusing, as I understand the question, on, and if we're at page 147 and the judgment citation of Palmer and Carey, on the underlined portion directing such person to pay such funds to the creditor. And Milady is envisaging the possibility that there may be within the facility agreement a direction in the sense that it is anticipated that disbursements would be paid out to NS's order, but by CLICO. Is that Milady's question?
And you put together the facility agreement and the development agreement.
Well, I think the first point we would make is that is a very circuitous, if I may say, means by which such an equitable assignment would arise. But we say that on a reading of the facility agreement, that there is no such sufficient direction to the counterparty, the other contracting party, namely NS, to pay sums out to the creditor, the creditor being NH, but because apart from anything else, NH would only ever be a creditor standing in a relationship with ICS.
ICS, of course, is responsible for the subcontractors, so it's enough if it's a direction to pay ICS. And of course, there are further documents dealing with ICS and NH.
Yes, there are certainly, there's correspondence that my friend took you to as between ICS and NH, but NS are no party to those pieces of correspondence, as the board will have seen.
No, but the question is whether or not, if there's an assignment to NH, sorry, by NH through this mechanism to NS, NS has ICS, sorry, pardon me, NH through the mechanism to ICS, ICS has a right which it can assign in the appropriate part to NH.
We say no, and one of the points that I perhaps ought to have taken you to, since my lady is and we say quite rightly, looking at the facility agreement and the development agreement, as it were, together, and as it were, gathering the intentions of the parties in that sense. What I ought, in that context, to just draw your attention to clause 10 and 42 in the development agreement.
Can I just ask, before we leave this page, who's envisaged as being the person owing money or holding funds belonging to the giver of the order? Is that CIB on the possibility we're exploring?
Well, CIB will hold monies once it's made the advances. I mean, obviously there's no provision for a separate account in our case, but there is a fund constituted by the advance.
Right. So that the hypothesis is that CIB, once it makes advances, holds funds belonging to NS, I take it?
Yes, it's the borrower.
Yeah. And then the equitable assignment is created by an order given by NS to the creditor, who I take it is NH, directing CIB to pay the funds to NH.
Well, I don't think NH comes into it at the facility or development agreement stage.
The general category of suppliers.
Yes, ICS or supplier. ICS will do.
ICS. Well, I see. So the order given. So there's an order. If you put all the contracts together, you can distill from them an order given by NS to ICS upon CIB holding funds belonging to NS, directing CIB to pay those funds to ICS, and the argument is that creates a valid equitable charge in favour of
ICS, which is a right it can itself dispose of. That's the point I'm trying to test.
This is just stage one, and stage two is for there to be a further assignment by ICS of its rights under this first stage in favour of NH. Right.
That's what I'm trying to ask counsel to help me on.
Yes. Thank you.
My lady, I'm grateful. We simply do not see that the facility agreement can be read in that way. The way in which we say the facility agreement must be read is that apart from anything else, one has to bring in the interests of the bondholders and the very clear specific trust arrangements that are made in relation to their interests. But then also, certainly it is right that there is this concept of disbursements within the facility agreement. But we don't say, we can't accept that there is some route through whereby parties other than NS have a direct and immediate interest in the facility. But that's a point of construction. I accept that.
I wasn't too sure, and I'm just being frank here, it didn't strike me the trust deed was going to help us as it stood. I needed to look at it for other reasons, because all that is dealing with is the surplus monies that come out of the company. If the company is actually disposed of assets, trust whatever, then they don't come into the waterfall which leads to the bondholders being paid.
Yes, but the principal reason why I took the board to the trust deed was because we here have relatively careful and elaborate arrangements which explicitly contemplate a trust relationship between other parties. And if there had been other beneficial interests contemplated, then might expect these parties to have drafted for those. And so it was that point that I wanted to make by reference to the trust deed.
Thank you.
I don't propose, in view of the time, to go to either the main contract or the subcontract agreements. The members of the board will have seen those. I propose very briefly, if I may, to look at the appellant's grounds of appeal. And if we could go, please, to page 1091 in the bundle. Grounds of appeal are there set out, and in relation to the trust issue, the point is made in subparagraphs A, B, C, and D that the Court of Appeal was wrong. And I'm reading now from A at the bottom of page 1091. The Court of Appeal erred in holding that the purpose of the facility agreement was to be construed narrowly as being limited to the financing of the project. Well, we simply say that there's nothing in the nature of an error in relation to that point. The Court of Appeal ought to have held that, having regard to the terms of the project documentation and the facts as found by the judge, that the purpose of the facility agreement was broader and included the payment of suppliers and providers of services, goods and services in relation to the project. Well, my lords and my lady, what we say in relation to that is that the facility agreement and its intent and purpose can be gathered from its express terms. And if there had been a specific intent to confer direct benefits on essentially second-tier contractors, then that could have been very easily achieved by drafting in the facility agreement and in the other project agreements. And the same point we say in relation to B, C, and D, that there is really nothing in the language of the project documentation which sufficiently creates a beneficial interest either in NH directly or in another contractor or supplier. And indeed, this is just a rather commonplace situation where there is a funder, a funding agreement. There is then a project lead who has responsibility for the facility and its repayment, and provides mortgage security and so forth. And then one has a series of tiers of contractor. And we are here dealing with NH at relatively bottom of the food chain, so to speak, seeking to establish rights by reference to these upper tier agreements. And we say that there is nothing in these agreements which would justify that. Perhaps if I could look now briefly at my learned friend's case, very briefly. It's paragraph 35 of the appellant's case. My learned friend spoke yesterday to there being, by reference to paragraph 35, 1, 1, 3, 4 in the bundle. Three points that he wished to make: A, B, and C. Trust for the benefit of third party, namely NH. Alternatively, obvious intention of the arrangements would be frustrated if there were not a trust in favour of NH. And thirdly, his point that where C, his client, NH, is party to arrangements, or their existence was communicated to NH. And I've dealt with that question of communication. We say that in cases A, B, and C, that there is simply not enough, nowhere near, we say, enough in the documents to constitute a trust in support of the trust point. And to the extent that my learned friend falls back on discussions or communings between the parties as found by the judge extrinsic to the project documentation, we say there is even less in that evidence, which of course is not challenged, wasn't challenged in the Court of Appeal, isn't challenged before the board. So we simply say that there is nothing, that there's nothing in the points that are raised on the appeal in relation to the trust point. In relation to the assignment point, we say first and foremost, agreeing with respect with the Court of Appeal, that there is nothing which would constitute a beneficial interest assignable by ICS, which must be the appellant's case. There is nothing which is assignable by ICS to NS.
Could I just ask you about that? It has, if the proper interpretation of the two agreements that I put to you earlier was correct, it would have rights under those agreements. Couldn't it just assign them as contractual rights or the proceeds of the rights? Isn't that assignable property in law?
Meaning that ICS would have, my lady, rights under the facility agreement directly, or rights under the development agreement, which are assignable to NH? Is that
I assume, just for the purposes of argument, and no, it's not your case, that there is an equitable assignment by those two agreements put together, and that the assignment is to, among others, to ICS, and it's to cover its disbursements, which would, of course, include what it has to pay to NH. Why is it your submission that the rights under such an assignment, if it existed, and I understand you don't accept it, if it existed, are those rights not themselves assignable property in law because they're straight contractual rights?
Yes, well, on the premise that my lady puts to me, yes, they would be capable of being assigned. I think the fundamental question where perhaps I differ
yes.
is the premise upon which that question, my lady, is put, namely whether the agreements read together confer rights, as it were, ab initio.
Understood.
And at stage 2, there would have to be something which amounted to an assignment.
Yes.
But we didn't look at in the subcontract, which says that the monies due in respect of NIHIC under the agreement will be assigned. I haven't used the word precise wording because you didn't take us to it, but the clause 17 is definitely there, isn't it?
Yes, yes.
Which clause 17 are we talking about?
This is the best place to look at clause 17, as Milady is probably recollecting it, is page 442 in the bundle. That is to say that the letter, ICS letter at 440, which then has a series of numbered clauses in it, and Milady is using the numbering from that letter. Is that's right, isn't it, Milady?
Yes, that's correct. Thank you. I couldn't find the page.
What I wanted to deal with very briefly, and in mindful of the time, I'll be very brief. Could I take the board, please, to the two new cases which are pursued before the board and which were not pursued before the judge or in the Court of Appeal. The first is to be found in paragraph 106 of the appellant's cases, bundle page 1162. If contrary to the above, NH did not acquire an interest in or rights to monies advanced under the facility agreement by an assignment from ICS, NH submits that it must be regarded as having done so by an assignment directly from NS. And my learned friend fairly concedes that this is a new point, but he says on the principles that he summarizes in paragraph 110, with which we don't disagree with those principles. He says, applying those principles, paragraph 111 of his case, that the new point is a point in effect, pure point of law. That's at the top of 1165, wouldn't necessitate new evidence, and then would be expedient and in the interests of justice. Well, the point that we make there is that this novel assignment case, being an assignment from NS to NH, was not pursued before the judge. That's obvious. But there are findings of the judge in relation to assignment, apparently relied on by my learned friend's clients. And of course, before the board, my learned friend pursues a case based not only on the agreements. He pursues a case on assignment based on letters, correspondence. That correspondence is, of course, between ICS and NH. There is no evidence in support of an assignment as between NS and NH. And we say that the problem with this new case is that it presupposes a series of facts which have not been tested. And in my submission, it would be wrong for the board to entertain this novel case, which is, of course, completely contrary, really, to the direction of travel on the assignment case throughout this long proceeding. So that's the point on that. Next, if I may very briefly take the board to paragraph 117 of my learned friend's case, 1167. Now, forgive me, I ought to just give this some context. If members of the board, you might go to 1165, we can pick up a heading Roman 6, entitlement issue. So we obviously have the trust issue, the assignment issue, and then the entitlement issue. And so that's the context in which this point arises. Essentially, NH argues that if all else fails, then NS has no entitlement to the frozen funds, etc., in any event. And it is in that context that we then have the italicized heading at 1167, estoppel in favour of NH. Even if, contrary to the above, NS could establish a good claim to the funds, NS conducted itself at all material times in such a way as to lead NH to believe that NH was entitled to payment of sums falling due to it under the construction subcontract from advances under the facility agreement. That is new, as my learned friend partially acknowledges in paragraph 119, 1168. He says this: although this estoppel case was not raised in precisely these terms below, it is not a new case, but an elaboration of NH's case based on principles governing payments, etc. This is a new case. It was not argued before the judge, and it didn't feature in the Court of Appeal. And in my submission, an estoppel of this kind, namely that there be, if NH has rights, that they are forfeit or precluded by operation of contrary conduct upon which I suppose it would be said NH has relied, that is all preeminently the territory of fact, and that there are no facts. That's the slight problem in my submission with paragraph 119. So we say that the two new cases sought to be pursued on this appeal ought not to be allowed. My lords, my lady, I was proposing to conclude my submissions at that point. You have the respondent's case, and I'm certainly, of course, happy to deal with any questions, but I propose to leave matters there.
Can I take you back to condition 17 of the tender acceptance? That's page 442.
Yes.
You'll see it begins by referring to all monies due to NHIC under the agreement. What do you submit that is referring to?
There is relatively little evidence to assist as to what that specifically means. There are, in my submission, my Lord Reed, two possibilities. One is that this is a reference to the facility agreement because of the preceding letter. Perhaps I ought to just take you to that. If I could take the board, please, to page 435. That is a letter from NH dated the 4th of June. It's a letter my learned friend took you to yesterday. And it begins: we would draw your attention to the following issues regarding the above project. 1, financing agreement. We require confirmation that the financing agreements have been fully satisfied and are in place. And one, of course, understands why any contractor would be wanting to establish that funding was in place. And then 2, assignment of loan proceeds. We require confirmation of the agreement that the monies due to us under the contract would be assigned and paid directly to us from CIB. Now that reference to the contract, we say that must be the contract between ICS and NH. In other words, NH are here asking about monies due under their contract, would be assigned and paid directly to us from CIB. So that, my lord, is the predecessor letter, and that is then the context in which the letter at 440 falls to be considered in my submission.
Does that make sense? Monies which were actually due under a contract to NH could hardly be assigned to NH.
Yes, well, it's very we say it's very difficult to discern what that may mean, because we obviously have I think the reference to agreement would seem naturally to be a reference to the financing agreement. Or alternatively, it might be said that we require confirmation of the agreement, might be regarded as a freestanding prior agreement reached between the parties. It's very unclear.
Well, I mean, one might think that the implication of this is that the money is originating with CIB, since the payment is to be made directly to NH from CIB. And when it talks about assignment, it's headed assignment of loan proceeds. So it may be, I don't know, but it may be asking for confirmation that monies owed to NH under the construction contract would be assigned presumably by the, I don't know, if it's looking for confirmation of an agreement that will be an assignment by NS, then obviously ICS can't give that confirmation.
No. There is, we say, something in this correspondence which, if my learned friend is right about the exchange, the meaning to be given to this exchange of letters, it involves ICS effectively promising something which it can't promise.
Isn't that where the notion of the equitable assignment might just come in? Under the development agreement and the facility agreement read together, if they constitute an equitable assignment of the fund, the advance to be paid by CIB to ICS at the direction of NS, then ICS has, this is the point I made before, a right which just at the moment it seems to be assignable.
Well, we say that one simply cannot read, and it's my prior point rather than the assignment point with which I've agreed, as it were. It's the prior point, namely, what is the meaning and effect of the facility agreement and the development agreement read together, and do they confer an interest on ICS, which is then capable, as Milady has explored, of assignment. And it's I don't disagree with the assignment point. The point with which we disagree is the proposition that the development agreement and the facility agreement together give rights without more in ICS. We say they just don't. And it would be a quite extraordinary route round the privity principle and a route round the language in those two agreements to arrive at that conclusion in my submission.
Lord Briggs, I think, has a question.
Yes, Mr. Hughes, I'll put it to you, and I hope that in reply, Mr. Ailiff will respond as well. But one way of looking at 435 and 442, so what ultimately becomes the assurance in paragraph 17 of the letter from ICS H, focuses on the use of the future tense in both the request on 435 and the reply on 442. Not that there has already been the requisite assignment, but that as and when a specific sum, say $200,000, becomes payable to NH under its agreement with ICS, then a Palmer and Carey type of payment order will be provided by NH and given to, provided by NS and given to NH through the good offices of ICS, so as to enable NH to request the money direct from CIB.
My Lord, that is entirely consistent in my submission with what we otherwise know about these contracts, namely that sums due under these contracts would be determined by a project quantity surveyor and so forth in due course. And so there is no, as it were, entitlement ab initio to sums payable under these building contracts, but rather entitlement accrues at a point in the future pursuant to the issuance of certificates and so forth by the appointed person. I think in this case a quantity surveyor, for example, under the subcontract, under the main contract. So in that sense, my Lord, the use of the looking forward to the future in the language would be appropriate and consistent with that.
Yes, thank you. Well, I'll wait to see what Mr. Elliott says about that as well.
Well, if there are no more questions, then thank you very much indeed, Mr. Hughes. And Mr. Ailiff, you have an opportunity to reply.
Thank you very much, my Lord. I'll try and be, again, as brief as I can, and I'll take these points in reverse order. So picking up, my Lord, Lord Briggs's initial point about the June correspondence and clause 17, we say that emphatically that isn't the way the arrangements were intended to work. Such an arrangement for an assignment of rights when monies fell due under the construction subcontract would provide no comfort or assurance to NH at the stage where it is deciding whether to enter into this contract and to mobilize in a foreign jurisdiction. What it wants to know is that it is assured from the outset that it is going to get paid directly from the loan proceeds. And if it doesn't have that right, then it has no comfort. It is ultimately going to be paid in due course. I see Lord Briggs has got a question again.
You may say this is small beer or small comfort, but it provides at least, doesn't it, the assurance once payment is due, they'll get it direct and not, as it were, have to wait for it to go round the houses through NS and then ICS and then trickle its way down to them.
It provides that very limited assurance, but what is ultimately the concern here, as my Lady Arden mentioned, is creditworthiness, that they're going to get paid at the end of the day, not the timing of the payment. So,
well, of course, that's been a concern of subcontractors for a very long time. It's one that's grown as more and more projects have been taken forward through the use of special purpose vehicles. It's not an unusual situation.
Well, I entirely agree, which is why my clients were so concerned to raise this point at the outset, as reflected in the findings of the judge, that this was raised in oral discussions in which the judge found that they got the oral assurances that they would be paid direct. These letters follow that, and these letters are cast in terms not of an administrative arrangement for payment. They're cast in terms of an assignment of rights to the loan proceeds. Now, arrangements for crystallizing precisely how much is due may have to be followed in terms of the appropriate certification has to take place. But what's agreed in advance is that once that certification has taken place, payment will come out of the loan monies. And that arrangement is not just a matter of timing, that is agreed in advance so that there can be no question of NS or ICS disposing of the loan proceeds, using them in some other way in the meantime.
So are you inviting us to read clause 17 as a legal assignment?
Yes, if one goes back, not a legal assignment, my lord, it's only going to be an equitable assignment, because a full legal assignment would require satisfaction of all the requirements of section 136 of the Law of Property Act. So it's an equitable assignment. But we would say, when one goes back to 435, the initial letter, which clearly envisages that there's already been agreement, and the judge has in fact found that there has been agreement for an assignment, and this letter is now seeking written confirmation of that, which is then provided. But even if I'm wrong and it is only agreement to sign, it's still an equitable assignment. Can be either an immediate assignment or it can be an agreement to assign. The only difference between the two is for the latter, consideration is required, which was plainly provided here. Now, and I'm not sure, just picking up this, I respectfully disagree with Lord Briggs's point, but I'm not sure it makes any difference, because in fact the monies were protected and were held by CIB and were ultimately ascertained, so that the right to have those monies paid directly crystallized at that stage. Which may be sufficient for our purposes, although we would say that wasn't in fact the arrangement intended. The arrangement intended was for an immediate entitlement to be paid out of the loan proceeds to be given to us. Although at that stage there were no loan proceeds, there were just contractual rights. I hope I've addressed my Lord Briggs's point there. And now propose to move on.
Can I just press a little bit more? On what basis, but one might ask on what basis ICS could assign, as you ask us to read clause 17, assign monies which were not theirs to assign. Are you asking us to regard them as acting as agents for NS?
Forgive me while I just we would suggest that really following the analysis of my Lady R, that ICS does obtain rights to the monies. If one starts from a very simple analysis of just NS is the borrower, is entitled to the monies, one then says, how can the rights to the monies have passed from NS to ICS? Well, we put it in three ways in our case, and in oral submissions I added a fourth one, and I'll just to summarize them now. The first two fall under the heading trust.
Yeah.
And we say, analysing the contractual framework, and in particular, the development agreement and the facility agreement, and in particular, clause 6.5 of the facility agreement, which contains a covenant by CIB to pay the monies, use the monies to pay ICS and suppliers. We say, viewing all that in the round, you can derive from that an intention on the part of all the parties who are parties to that agreement, that there should be a trust of the contractual rights to those monies. And in due course,
and if it's a trust, you don't need an assignment, equitable or otherwise, because you already have a proprietary interest.
Yes, but this is just ICS we're talking about, so it doesn't get to us on this analysis. I'm just providing my explanation of how ICS gets rights.
Yeah.
So ICS gets rights under a trust. The first limit of that trust is the way I've described it. You just look at the contractual arrangements. You say there is an intention here that it should all come to ICS. The alternative trust analysis is, you say, look at the context in which NS entered into the loan agreement, the facility agreement. It did it against the backdrop of the memorandum of understanding and arrangements under which these monies were going to be channeled to ICS, to enable ICS, who is the party carrying out the project and incurring all the indebtedness, to be paid. We say that's a classic kind of situation where one can find a trust of a promise, which would give ICS the benefit of the rights. Now, those are two different ways of analysing it in terms of a trust. The alternative way of looking at it is to analyse it in terms of an assignment. And the way we did it in the case was to say that what clause 6.5 does is assigns NS's rights to ICS. NS, who has the benefit of the loan agreement, says in 6.5 to CIB, agrees to CIB undertaking 6.5 to pay the monies to ICS and suppliers. And we say that operates at the very least as an assignment to ICS. We don't try and extend it, although one could arguably extend it to NH, but we don't need to because there is then specific agreement regarding NH. But that's the first way to view it, an assignment of NS's rights to ICS. The second way, and the one I developed in addition in oral submissions yesterday, was simply to rely upon CIB's direct covenant in 6.5 of the development agreement as being a contractual right in favour of ICS to receive payment from CIB. Now, those are four different ways to end up with the conclusion that ICS has the rights to the loan monies. Initially, the contractual rights, and then when they're paid, the loan monies. And they also reflect, I think my Lord Sales put 2 points to my learned friend yesterday, which were putting it both in terms of trust and contractual analysis. And I've really just tried to flesh those two out. So that's, my Lord Reed, is how we say ICS has got the rights if they don't end up going directly to NH. The next question is, and I won't dwell on this because we've really just been addressing it.
Sorry, I was going to say, mine was, the proposition I put to council was slightly different because I read clause 6.5 together with the contemporaneous agreement to make it, to ask whether there was an assignment in favour of ICS by the combination of those two documents, the debtor being, of course, NS. CIB
yes,
being the
I probably haven't put it as clearly as my lady has, but I think I was endorsing that point by saying clause 6.5, but obviously read in the light of clause 3.1 of the facility agreement, which sits so comfortably with it. And my learned friend accepts that the monies were to be dispersed by CIB to pay suppliers. So we say it all fits very conveniently together. And bear in mind, at this point, we're just looking at the initial project documentation. It's hardly surprising to find that when NH queries the arrangements and asks for comfort and assurances, it gets them. And to the extent there's any gaps in the arrangements as set up under the initial documentation, the initial project documentation, they are filled by what happens subsequently. But so we say ICS, to go back to the thread of argument, ICS has rights by those routes. The next question is, does it assign them to NH? And we say the evidence overwhelmingly establishes that, both in terms of the owner of the rights, ICS, saying to NH, you can have them, but also in terms of the owner of the rights, ICS, saying to the debtor, CIB, the obliger, please pay them to NH. And one gets it from, there's an oral agreement, which the judge found to that effect. We have these letters, which are, when read against the backdrop of the oral agreement, is found by the judge, and read together, the two letters in clause 17 can only evidence this assignment. And we also have what subsequently happened, which was ICS telling CIB and arranging with CIB, the minutiae of how we organise this, which is we'll take out of each advance a chunk for NH, put it aside. Neither ICS nor NS will be able to go to that money, and CIB is to pay over to NH, subject only to receipt of the engineer's certificate. So we have all the links in the chain to get an assignment of rights via ICS to NH, which may be a convenient point for me to turn to what is said about, well, what if, for the sake of argument, NS had the rights and they never got to ICS. And this is our new argument. But my my learned friend says, well, it's a new point. You can't raise that now. You can't find, there isn't a necessary findings to raise that. But with respect, the judge has made all the necessary findings. All the relevant evidence was there. The judge conclude, and this is where the passage my learned friend referred the committee to, the board to, paragraph 138 of the judgment at first instance, which is at page 141 of the bundle. And this is a passage where the learned judge concludes, on the balance of probabilities that ICS agreed to assign and did assign the monies payable to NH. This is after the judge has reviewed all the oral evidence and so on. And his conclusion, it's hardly surprising to find it expressed in terms of ICS, because that's what was being argued before him. But if you go to his earlier findings about what happened, and I won't take up time going through them, but a fair reading of those findings shows you that he considered that there was agreement by both NS and ICS for this eventuality, that for the eventuality that NH should be entitled to the loan monies. Just for your references, paragraphs 115, 119E, 131, 133, 136, 137, all are important paragraphs where the judge deals with the factual issues. And in one of them, he mentions in passing, it's paragraph 133, he refers to matters which are suggestive of Mr. Imbert also representing NS. Now, Mr. Imbert was a director of NS so, at the time, but he actually thinks that Mr. Imbert is there representing NS. So, although he frames his conclusion in terms of an assignment from ICS, his finding was that NS also agreed to this arrangement. And therefore his findings support the conclusion that there was an assignment by NS if it transpires that NS had the rights to the monies. Now, I know NS might say now that, oh, well, even though we were a party to the agreement for the assignment, we were only agreeing to an assignment by ICS, not us. But that would be a nonsensical suggestion. I mean, the fact that they were party to that agreement shows that they must have thought that ICS had the rights. It really goes to show that they believed that the rights to the monies lay with ICS. But to the extent that's not the case, and if they'd thought otherwise, they should plainly have said so. And it's hardly surprising that we run the estoppel argument we run if it is really necessary to do so. So we hope that in those two ways we've covered whoever the rights either belong to NS or they belong to ICS. We say that actually it's ICS and they were assigned on, but if it's NS, they were assigned as well. I'll just try and pick up any other points. It might assist if I just go back to there was an exchange between Lord Reed and my learned friend about Palmer and Carey at page 47 of the bundle. And just to clarify,
I think it may have been 147.
Sorry, 147. I do apologise. Thank you, my Lord Reed. Yes, thank you so much. That's correct. Just to clarify what we would say about that. The quotation from Lord Truro, reading from that, the extent of the principle to be deduced is that an agreement between a debtor and a creditor. Now, we would say here the debtor is NS and the creditor is ICS. This is under the construction main contract. NS is going to owe monies to ICS for the works ICS is going to carry out. And then continuing, that the debt owing shall be paid out of a specific fund coming to the debtor, or an order given to the debtor. Now that specific fund is the loan monies, or an order given by a debtor, NS, to his creditor, ICS, upon a person, in this case it would be CIB, owing money or holding monies belonging to the giving of the order, directing such person to pay such funds to the creditor, ICS. So we say one can fit the present case very neatly within this. The person is CIB, it's holding monies that belong, but for these arrangements, to NS. And NS is going to owe monies to ICS, and it gives a direction to CIB to pay the monies to ICS. And we say that is accomplished by the 6.5 of the development agreement read together with the facility agreement, and achieves an assignment of the monies to, if one follows the assignment route, to ICS, the rights to the monies, which is then passed on to NH under the oral agreement, the June letters, and subsequent conduct. I think that has covered several of the other points I was going to raise.
Can I just ask you, in that passage, are you relying on the first alternative or the second?
We rely on both ways of establishing an equitable assignment. The two ways are an agreement between the assignor and assignee that the money should be, the assets should be transferred to the assignee, and a direction by the assignor, the owner, to the obliger to pay to the assignee. So,
and where do we find the direction?
The direction is in clause 6.5 of the development agreement, which contains an agreement by CIB to pay direct to ICS and suppliers.
And to bind NS, it's also in the other agreement.
And it is also, one can go, if one goes back to the memorandum of understanding, and one also finds it reflected in the facility agreement. But the key point, I mean, I agree, my Lord Reed, that it's not framed as a direction, but clearly it's a consent and a direction. It's NS, ICS, CIB, and the government, for that matter, all parties to an agreement under which it's agreed that CIB should pay to ICS and suppliers, and so it meets everything. And my learned friend did move on to mention the clause in the development agreement prohibiting assignment without consent of other parties, but he didn't develop a submission based on that, because clearly you can't make out an objection based on lack of consent, because the consent is there in the very agreement.
Yes, thank you.
So just coming back to the first point, I think my friend made this afternoon, based on he said NH was unfairly criticising the Court of Appeal's approach, and he tried to suggest that the Court of Appeal did approach matters in terms of an inquiry as to intention of the parties and whether there was an intention for NH to acquire interests. We don't dispute that the respondent NS had always said that intention was critical. We had been saying that as well. But the Court of Appeal, as one can see from its judgment, seemed to have lost sight of that. And that's very clear when one looks at the way the Court of Appeal crystallized the issues for them to decide. They didn't crystallize them as what was the intention of the parties, was there a trust? They crystallized them as what was the purpose of the facility agreement, was it fulfilled or not? And the only way one can get to that, they don't explain how they crystallize the issue in that way, but the only way one can get to that is by reading it as an understanding that what was being asserted was a quis close trust. I think that covers all the points today. There is, just picking up a couple of points from yesterday, Mr. Hughes repeatedly made the point below. He suggested that the parties and the judge had treated the issues as turning on an analysis of the project documentation. Well, I mean, we say that is not correct. And the judgment at first instance makes that clear enough itself, because one can see the judge referring to many other passages and where he's looking at and making findings about factual matters that he considers relevant to both the assignment and trust arguments. But I should also just show the committee what was said in the opening submissions at trial at page 632 of the bundle. These are NH's opening written submissions at the very opening of the trial. And they start in paragraphs with preliminary statements in 1, 2, 3, and 4 referring to the facility. But if one picks it up at 5 and reads through to 9, one will see, and it may be we don't need to take time up now doing it, but if I can just give that reference for your for the committee, one will see the NH referring to the oral agreement, the subsequent to the letters, and the subsequent conduct, and that's at the heart of its case. So when Mr. Hughes took your lordships, your ladyship, to paragraphs 45 and 47 of this document to try and suggest that, well, actually it was all about the project documentation, he was literally just taking one little snapshot of the submissions, which were focused on the project documentation, but was ignoring the bigger picture. And the other reference I'd just like to give the committee is at paragraph 4.1 of NS's opening written submissions, which is at page 693. It's perhaps not necessary to turn to it, but I'd just like to draw the committee's attention to the fact that NS describe, and I quote, the linchpin of NH's case in both actions as the alleged oral agreement, which they refer to this by reference to what the statements of case, but if the statement of claim, but if one looks at the paragraph they refer to, it is the oral agreement. They see that as the linchpin of the case. So it's always been about these other matters, but of course the project documentation is there in the background and it is relevant, but the case has been about a great deal more, and it didn't change on appeal. If one were to take the time to read all of the skeletons, one will see the same issues fleshed out in the skeleton arguments. And I think that, unless I can assist the board further, I think that covers one final point. I mean, it's not legally relevant, but it's this windfall point, which Mr. Hughes came back to. And he said that ICS and NS had to complete the project without the benefit of the frozen monies. Well, of course, that is correct. But NS ultimately received repayment, it ultimately received the benefit of the frozen monies because the loan was repaid in full by the government. So it later got the frozen monies. If there were any issue about it not having the frozen monies. It's simply a short-term issue of funding in the meantime. As to their allegations about having lent substantially more monies to NS, having lent to ICS, NH doesn't dispute that further monies came from CIB to facilitate the lending, the completion of the project. That was demonstrated by a further indenture in evidence at trial. But what NH has always disputed is the allegation of this further lending. It's highly unlikely where would NAS have got this money, but the judge made no findings on this. And Mr. Hughes suggested it was a sort of accepted fact, and he referred to the statement of facts and issues. But actually, if you look at that statement of facts and issues, it's not necessarily turned to it, but paragraph 31, all it records is that the NS claims that there was a loan. NS insisted on reference being made to this point, and we agreed to going into this statement of facts and issues as a reflection of this is what they claim. But there's no factual findings that it's the case at all. So, my lords, unless I can, unless I can assist you further, those are my submissions. I should just say on cost, which we didn't cover in the case, our position is costs should follow the event. So we should get them if we succeed, the NS if they succeed, unless, of course, the board were minded to make some other order in relation to the outcome of the case, in which case we'd welcome an opportunity to make submissions.
Well, I don't think we have any further questions for you, Mr. Ailiff. You've dealt very fully with the many questions that we have asked. Well, we're very grateful to all counsel for their assistance. It's obviously a tricky case. We'll now take time to consider our decision. Thank you very much. The court is adjourned.